the first thing you need to appreciate is, okay, what you need to appreciate is what type of transaction do I have? Is it a corporate transaction or a commercial transaction? So the question is, what are the different commercial transactions? Among commercial transactions, we have one, okay? We have partnerships, okay? Then after partnerships, we have companies, okay? Then after companies, we have establishment of financial institutions. Then after financial institutions, we have joint venture. After joint venture, we have sole proprietorship. Then after sole proprietorship, we have trustees and NGOs. All those, we are establishing business vehicles. When you look at the establishment, it doesn't require any use of money. Exchange, okay? That you work, I pay. That's why it's called a corporate form of transaction. Then we have what we call commercial transactions. These commercial transactions, basically, they deal with exchange of money, okay? And if you have authoritatively looked and appreciated the same, one, we have what we call employment, okay? So when you are dealing with employment, you expect to pay the employee, you as the employer. We have what we call exchange of money. So that's why it is referred to as a commercial. Why? Commercial will deal with money. Okay. So after employment, we have another one known as procurement. Procurement is buying or purchasing something. Can you purchase something without money? Okay. That's why it is also a commercial transaction. Okay. Then, if not employment, procurement, what else that deals with exchange of money? We have sale of goods. Can you buy or sell a good without expecting money? That's why it is also a commercial transaction. Then we have what we call franchise. Have you ever seen anyone starting up KFC without expecting to get money? Okay. Then, if not, have you ever seen anyone who starts a petrol station without expecting money? Okay, that's what we call franchise. Then we have another one known as agency. You want to be an agent who is paid. You see, have you ever seen someone who starts up a mobile money kiosk without expecting proceeds at the end of the month? That's why they are called mobile money agents. They are agents of MTN Uganda. Okay, bank agents. Okay, you establish the same, knowing that if we make numerous transactions, we shall get money at the end of the day. Okay, then you have distributorship. You've seen people, when you go to Mbarara, you know that we have one shop that deals with incorporation. Have you realized that? Okay, go to Forfeiture, we have one shop. of M. Go to Mubende. Why? Distributorship. You to become a distributor, you have to do what we call monopolization. Okay? When you are, for example, I'm not seeing, we have what we call depot. Okay? Those are distributors. When you go in an area, when you go to the town of Fort Portal, how many deposits areas are there for Coca-Cola? It is always one. You know why? When you go, you want to become a distributor, they give you the soda. A bottle of soda is sold, okay, at 800. Okay? So for you, they tell you, fetugenda kuwa buli crate ku mitwalo emeka ebiri nete tukusasula. Okay? So they set what we call the maximum nti oyina okutunda bwoba mweno locality soda tasukka 10,000. That's why now ogenda okugenda nakakoko ka 10 meka biri ojja kanyu naye ate ojje kagugu kagule meka 10,000. Lwaki wali n'ogenda ku Serena ne bagamba ka mutwalo ate n'ogusasula ng'oli mukakamu? Why? But it's the same soda. Okay? But when these guys enter into that agreement of distributorship, they set the maximum the soda taina kutundibwa kusukka mutwalo echupa. Ojagenda newo ogenda ku Serena n'ogenda ku Skies, tewola ba soda were the same price. Era again, when you enter into baga kutunda Coca-Cola products zokka, osobola ogenda ku Serena ne batakuwa Novida. Why? They enter into that agreement. Nti fe tutunda bya Coke, fe tutunda bya Pepsi Cola. You are a distributor of that product. Tokkirizibwa bana abana ku maduuka ba distributor bagabira fridge eya Coca-Cola bagisenge mu Pepsi. That's distributorship. So they give you the maximum, so it's upon you. Either you maximize or you minimize. So they don't pay, but you enter into such an arrangement, okay, with an expectation of getting at the end. You are getting money. So that is also a commercial transaction. So whenever you are having a workshop, before you do anything, first ask yourself, what transaction am I dealing with? Is it a corporate transaction or a commercial transaction? That is the first step in interpreting corporate and commercial. Once you learn that line first, you are good to go. Okay? Then, LDC, they will never tell you that today we are teaching a corporate transaction. Today we are teaching a commercial transaction. It is upon you to sit. If God has helped you and you get that concept, you will be able to tell. So the fact is, in first term at LDC, they only teach what we call corporate transactions. You can testify. You started with a partnership. Okay? Then after, you started companies. During that very workshop, you started NGOs and trustees. You are still proceeding with companies. And they are the very topics we've listed under the corporate transaction. So, second term, you are going to shift to what we call commercial transactions. Zonanga wetuzogeddawo. Trust me, those are the weeks you're going to have in corporate and commercial. It is going to be a marathon than ever. You see that the commercial transactions are many than the corporate transactions. If you've been complaining that first term corporate has been huge, what are you going to say in second term? A workshop is going to come with the sale of goods together with the procurement. You get the act when it multiplies that book times 4. You say, hey, Kabaka Mwanga. Okay? So whenever you get a question, first ask yourself, what am I dealing with? Is it a corporate or a commercial transaction? Then after getting that thin line, all these transactions, they have what we call stages. Okay? A transaction basically has 3 to 4 stages. Whenever you are reading a question, ask yourself, the transaction I have, yes, it is a corporate transaction. Which transaction in corporate? That it is company. But this transaction is at what stage? Why? If you fail to locate the right stage, you're going to give a wrong remedy. Okay? This has never happened to you. You people, your colleagues failed the last IA because of that interpretation. Prince Wambuka stood here at the entrance of the auditorium. He was even laughing in capital letters. You fools, how can you dissolve this company? You don't read, you have empty heads. Guys started pleading. Why? It was the last IA of life when it is counting. And even the second last, they misfired 90%. So when someone knew that, the other one has misfired, this one I'm misfiring, that means in IAs, I have nothing. Day. Nagamba one. So guys argued with Mwevembes the whole day. Naga cancel. Yambo way. We've learned. But they had no option. Okay? So you couldn't force him to do the same. Okay? So the stages of a transaction are: 1, establishment. Establishment. That was your very first workshop when it was saying that advise the parties on the appropriate business vehicle. They wanted you to discuss the stage of establishment. So either you know how to establish a company, you know how to establish a partnership, you know how to register an NGO, you know how to register a trust. You remember what happened when they gave you a workshop on trusts. Some of you did the ordinary trust, others a corporate trust. Why? You had issues with establishment. So when you are dealing with that stage of establishment, it deals with registration and incorporation only. So whenever a question comes, ask yourself, does it require establishment or not? You see how you will do dissolution when you have not established. That's what also happens in family. You want to dissolve a marriage that never existed. Okay? You want to adopt someone when the client has told you, I want to stay with him temporarily. We no more adoption for child guardianship. They give you an imminent danger, okay, which requires someone to proceed to get a care order so that the child is placed under a foster home. Hey, no more guardianship. So why? It takes you back. What stage? So in corporate and commercial, whenever you say that, yes, it is established. Okay, so I've said that when you are dealing with establishment, Even the law, you will be able to tell that now I want the Partnership Act. I want to, after the Partnership Act, because you know that I will need a name. I need the Registration of Business Names Act. That okay, if I get a name, what else do I need? Which type of partnership? That it is a professional partnership. I need the Advocates Act. I need the enrollment rules. After that, I need to approve my chambers. I need the approval of chamber regulations. So, okay. So even you will limit yourself to particular laws, but some of you, when you are looking for law applicable, what you do, okwata bulungi act n'ogikyusa votes n'okoppa buli ekiriko. You are copying the law that okay. When I'm marking, I won't be wrong. That means you are a student who does not appreciate. Okay. So when you look at that first segment of establishment, it requires that process of establishment. Only after establishment where to come back, you don't add on. That's why your first workshop of company was on promoters. Then the next workshop was starting from member, shareholders, directors, and auditors. But you didn't realize that. Okay, so your workshop 1 was basically dealing with establishment. Why? The duty of a promoter is establish a company. Upon establishment, this person ceases to be a choose a title. So that means after establishment, what next? So our second step is management. Because you can't establish something that shouldn't be managed. So when a question comes in management we shall always have conflicts. Who is taking it? Who should be the leader? Okay, that's how you'll get a question in company. Okay, which basically requires one thing, not a gala like this. They will ask you appointment of a director. No tagala, no zunga, no dairy. But Ojakuda, why are you looking at what is a company, to be honest, when you need management? Why? When you read Article 8, it is very clear. Management of a company shall be done by directors. So that means when you are dealing with management, you are dealing with the stakeholders of the entity. That's why in a partnership, when you guys were dealing with management, you dealt with who is a partner, the different types of partners, how to bring in new members, and how to expel. That is in a partnership. Then in a company, that was your workshop 2. Okay, the first forgot the meetings. Okay, members, where did you stop hearing me?
Registration.
Management.
Yes.
Management.
Okay.
On the part for partners, how new partners join, then dismissal. That's where we stopped.
Okay, so what when we've said that the third step is management. So you have an obligation to ensure that you appreciate the different things in management. So when you are dealing with management, you have to solely appreciate. If you are dealing with a partnership, how do you manage a partnership? Who does the management? If you are dealing with a company, who does management of a company? That is management. Okay. Then if it is a trustee, who manages a trustee? We have the board of trustees, management. Okay. Then we said after management, we shall proceed to our next step, which is known as dispatch of business. So you should, when you are dealing with dispatch, first things first, you should ask yourself, how do we dispatch? In a partnership, we dispatch by consensus. Mere sitting and agree that let us add Anita, okay, on our team. It is sufficient. Okay, very sufficient, because we have agreed. But in a company, it is not a mere agreement. We have to sit and enter into an agreement by passing a resolution which emanates from meetings. So that means in a company, dispatch of business is done by meetings. That's what you're having today. So when you are dealing with companies on that part of dispatch, first ask yourself, what business are we dispatching? So what are the different types of businesses that a company does dispatch? Okay, then you say, one, you have borrowing. Two, amendment of articles. Three, amendment of memorandum. Four, okay. Four, okay, increase of share capital. Five, decrease of share capital. Six, borrowing. Okay. Seven, making a call on shares. So all those are businesses that are dispatched. So you should know each business, when is it done? At the end of the year, during the middle of the year, and by who? Okay. We have businesses that are done by the directors only. We have businesses that are done by the shareholders. So you should be able to differentiate, and that is the gist of our workshop today. Okay. Then the last step is always dissolution.
Someone's mic went off when you're reading them out. Kindly.
Okay. We are going to repeat them, so don't worry. Okay. So the last step is always dissolution. That's why your last workshop in partnerships was dissolution of a partnership by agreement, by influx of time, by law, by agreement. Then also here, your last workshop, okay? Your last workshop in company will be, what is the last topic in company? Yes, it will be insolvency or winding up, because that is how we dissolve a company. Very simple as that. Okay, so don't get scared of corporate and commercial. So that means in your first term, you've been solely dealing with corporate transactions. So basically for today, allow me zero down to the transaction known as company. So we are dealing with a corporate transaction known as company. So you had workshops on company. This is the second last workshop. Okay. So we are under an obligation to appreciate. Okay. The second last where you will stop dealing with company will be in your third term, which is insolvency. Okay. It is the last workshop. So now let me do my level best. I break the company. Okay. So if you want to appreciate this corporate transaction of company, what things should you put into consideration? We always have a clear modus operandi of a questionnaire approach. If you set down questions, when you follow those questions, they will always guide you when you are appreciating. So we are setting the questionnaire that is going to guide us in reading our law of company. First things first, what is a company? What is a company? Okay. Then after, because when you look at the Companies Act, it defines a company to mean a company incorporated under the Companies Act. Don't add on. We've always had a mistake when you ask someone what is a company, say Salmon versus Salmon. That case doesn't define a company. It gives you what we call effects of incorporation of a company. Okay. So now, after you've appreciated, it is section 2 of the Companies Act as amended. After defining what is a company, then ask yourself, what are the different types of companies that we can establish? Okay. Okay. Under this, basically, when you look at the setting, we have two types of companies. We have a private company and a public company. They are only two. Okay. So it is upon you to ensure that you appreciate the different types. Okay. If you are dealing with a private company, when you look at section 4, okay, of the Companies Act as amended, it gives you the different types of companies. They say a private company is a company that limits its numbers to, what's the maximum number in a private company? 100. So that means the membership in a private company doesn't exceed 100 persons. Then the same law, okay, proceeds and gives you another thing you consider to say it's a private company, okay, which says that, okay, it restricts transfer of shares to the entire public. Okay. It restricts transfer of its shares. So shares don't go out of the company. Shares are only transferred to members within the company. We don't invite the public. We are private in nature. Okay. Then it also limits its invitation to only its members, not the public. Okay. Yes. Okay. Then after putting that into consideration, a private company is further categorized into other categories of private companies. Okay. Under categories, we have one, limited liability companies. Okay. That's the first category. Limited liability companies. Okay. Then limited liability companies are also divided into two. Okay. We have a company limited by shares and a company limited by guarantee. A company limited by shares is also defined under section 4 to mean a company whose liability is only limited to the unpaid up shares. Okay. Okay. Then we have a company limited by guarantee. A company limited by guarantee, it is a company whose liability is limited to the undertaking. Okay. Undertaking in Uganda, how do we call it? The simplest way it can be a pledge. What you pledge to give us, that will be your liability. Okay. Then if it is not a company of that category, which is a limited liability company, it can either be a single member company. Okay. So single member company regulations, they define that company, okay, to mean a company which is fully owned by one member. Okay. Then if it is not a single member company, do you have any other type of a private company? Okay. Then the second type of a company is known as a public company. But at LDC, they don't teach you public matters. They want things that bring money. Okay. So whenever you are dealing with establishments, you should first ask yourself, according to the facts I have, what vehicle? You can say it is a company, but basically what company? All those things answer that. Okay. Then after understanding what are the different types of companies, then ask yourself, how do we establish a company? Okay. Okay. Just a private company. The act defines a public company to mean a company which is not a private company. That is the definition. Okay. Yes, section 2 as well. Council Edward, please hold on a little bit. Yeah. Section what? Okay. What section 2 defines, then it sends you to which section 6. Not so? Yes? No. The definition section of a Companies Act is which section? Okay. Okay. So now the presumption is you've appreciated what type of company your client is intending to establish. Then ask yourself, how do we incorporate a company? Or how do we establish a company? Simple as that. Section 4, as amended, because that section was amended, it says any one or more person may incorporate a company by filing registration form. By filing registration form 1. Okay. Okay. Incorporation. Okay. So initially, before the amendment, the first thing we had to consider was memorandum and articles. But currently, the registration form is accompanied by memorandum and articles of association. So you, as a result of that, you look at section 7, okay? Section 7, which talks about the memorandum. Yes. Okay. The registration form. So the registration form is accompanied by the memorandum and the articles of association. Okay. Memorandum and articles of association. Okay. Then after that, you pay what we call registration fees under the Stamp Duty Act. Okay. The Stamp Duty Act. We are answering the how. Okay. Then after that, okay. Then after that, but because when you look at the memorandum, okay, and when you look at the Form 1 that we are referring to, Form 1 has something that is required, the business name. So what that means, the very first step is getting a business name, okay? Then 2, filling in the registration form, drafting of the memorandum and articles of association, then filing for registration upon payment of court fees. So registration fees. Okay. Then after, you will be given what we call a certificate of incorporation. Okay. Once you are given a certificate of incorporation, you cannot just proceed and carry on business. Why? Section, no person shall carry on business unless he or she is in possession of a valid license. So that means the last step will be, okay? Okay, so when you look at that, that's application. Okay, so then after that, okay, it makes it an offense for you to operate without a trading license. So that means after you've obtained a trading license, you are free to commence business as a company. So that means now your company is incorporated. So we've answered the how, not so. Are we together, guys who are online?
Yes, Council.
Yes?
Yes.
Yes, we are on, Council Rashid.
Okay. So now we've answered our question of how. Okay. Now we want to know what happens after incorporation. Then we get our next question known as what are the effects of registering a company? What are the effects of registering stroke incorporating a company? Okay. So when you look at the amendment of the Companies Act, the amendment, okay, that is section, which section? Section 2, subsection 1C. It has all the effects of incorporation. 1, a company becomes a body corporate. That's the first effect. Okay. Under section 2, subsection 1, paragraph C. Then after citing that section, you bring the case of Salmon versus Salmon. Okay. Now, another one is known as capacity to contract, also under the same provision, section 2, subsection 1C. Upon incorporation, a company has capacity to contract. Then you cite our famous case of Lee versus Lee Air Farming Limited.
Council, I beg pardon on that section.
Council, I am lost.
Okay.
We are, yes, okay. We are answering a question. We've incorporated a company. Then we got another question, which is known as what are the effects of incorporating a company? So we've said all the effects you need are under section 2, subsection 1, paragraph C of the Companies Act amendment. Yes, okay. Okay. So then, after that, okay, you ask yourself, what are those effects? So, when you are reading section 2, when you are reading section 2, subsection 1, okay, it gives you the first effect, which is known as, okay, that we've cited, okay, corporate personality, okay, that is one which is under Salmon versus Salmon, okay. Then we've said the second effect is capacity to contract, and you've said that this was stated in the case of Lee versus Lee Air Farming. You remember the fact, Council Master, so? Yeah? Lee versus Lee Air Farming. Lee was the director of Lee Air Farming Limited. These guys wanted to transport some grass. So they hired, they thought of hiring services of a pilot. So Lee himself hired himself and he signed on behalf of the company. So on his way, crashed and he died. So the wife sued Lee Air Farming Limited for compensation. And the council's argument in court was that in such circumstances, Lee was the same person. So court said no. Lee Air Farming is an independent entity from Lee, which has capacity to contract and hire any person of its choice, under which it hired Lee. So it had to pay. Okay. Then we have another effect is known as perpetual succession. Perpetual succession means the company does not die. Okay. A good example, we've seen a BMK group of companies. Didn't BMK die? But aren't we having BMK group of companies? Okay. We have Zimwe Construction. Upon demise of Zimwe, what happened? Okay. The company existed. Okay. We had a Kalita group of companies. What happened? Just that, okay. So why? Upon death of the directors or the shareholders, the company remains. That's what we call perpetual succession. Okay. Then another one, another effect of incorporating a company, capacity to own property. You've seen titles where companies are registered as owners. Upon incorporation, a company becomes a person who has a right to own property under Article 26. Okay. Now, after you've looked at the question of what are the effects, then ask yourself, what documents are supposed to be filed upon incorporation? These are also known as mandatory filings. What documents are supposed to be filed upon incorporation. So these are also known as mandatory filings. Okay?
Stop what? Documents?
Yes, documents that are supposed to be filed upon incorporation when it is mandatory. Okay? That's why they are called as mandatory filings. Okay? We said these include but not limited to. We may not be able to exhaust all of them. The first one is under section 61, which is, okay, return on allotment. Okay? Return on allotment. Okay? Then another one is under section 119. Okay? 61. Okay? We have another known as the register of members. It's under which section? The section
Before the register, council,
okay.
You talked about some.
The first one said it is a return on allotment. Okay. Yes. Then we have 119, register of members. Okay. Then we have 119 capital A. Okay. It creates another mandatory document known as the register of beneficial owners. Yes, it is an amendment. Okay. Then another one, we have what we call a notice of state of business. Ogenda kolerawa. That's what we call a notice of state of business. Yes. Okay. Okay.
Which section is that, Council?
Okay. Look at section 116. Okay. We have so many other mandatory filings. Okay. Yeah. No, it's the same. Okay. Yes. Okay. So now, after we presume that you have done the mandatory filings. So now the company is ready to carry on business. But as you are carrying on business, ask yourself, who will manage your company? Then that takes us to who manages the company. Okay. Who does management of the company? Okay. So the general rule is under Article 80, Table A, which says that the management of a company shall be made by the directors who will pay, who may pay and run, who may pay the promoters and run all business of the company. So the general rule is management of a company is done by directors. Article 80. Okay? Table A. Then after that, ask yourself, who is a director? Okay? The definition section is very clear on defining who is a director. Okay? It says that a director is any person occupying the position of a director. Simple as that. Okay? The position of a director. Okay? Then, after appreciating that who is a director, ask yourself, what are the different types of directors? These are directors that you know very well. The first one
Council, we are not getting you. You're breaking,
We say
Council.
the first
Please.
one is a shadow. Okay, sorry, I'm back. The first type of a director is a shadow director. When you look at, again, section 2 defines a shadow director to mean a director who does not actively participate in the management of the company on whose directions the company is being run. Okay? Order from above. That person doesn't appear, but this person gives orders. Okay? Section 2. This person gives orders that, you know, I want that one to do like this and this and this. And you tell that someone, go and eat your mother something. Okay? Yes? Okay? Statutory. Yes. Okay? Well, the definition in the Act is a shadow director is a person in whose directions a company is being run, but doesn't include we lawyers who give legal advice. Okay? This person is the owner, but this person stays aside. Okay? Now, government your money in your company, okay? Yeah. So this person gives orders. No reception, or no. Okay? Why? This company will be run according to the wishes of this person, but you will never see. Okay? That's why you hear rumors. Okay? Hamtawazan. Simimani. Okay? Akamwesi. Muze yetulaliko akamwesi. Buli lunaku. Muchinuche na akomba kabiri. And you keep on saying ebizimbe si bibyo. Okay? Walionga akola sentence. Okay? So that's why we have order from. That's the literal meaning of a shadow director. Then after shadow director, we have what we call a nominee director. Okay? A nominee director. Okay? Yeah, those are mentioned under the Act. That's why they call it statutory. Okay? So a nominee director is a director who takes on a single member company upon death. Mark that, upon death of a single member. You'll get in orals. They tell you to differentiate all those types. Okay? Then, if not a nominee director, the third type will be the alternate nominee director.
Nominee council.
Okay? A nominee is a type of director, okay, who takes on a single member company upon demise. Okay? Upon demise of the single member. Okay? Then after nominee, we have what we call the alternate nominee. Okay? Alternate nominee director. Okay? So, an alternate nominee director is a director who takes on a single member company in absentia of the nominee. So, what does this mean? Single member bw'atafa, gwe nominee jasigale mu kisenge paka. Hajati nambemu bw'atalwala, tetujja genda wa namba 2. Okay? Namba 2 bw'aba taliiwo nga ne Hajati mulwadde, tetujja genda wa namba 3. So either loga namba 1 afe, namba 2 alwale, yukenzitia wa namba 3. Okay? I'm just using them for academic purposes. Okay? Whatever we've seen, those 3 types of directors, they can easily be classified as statutory types of directors. You know why? They are provided for under the Act. Okay? They are provided for under the Act. That's why they can be called statutory types of directors. Then we have other types of directors which are known as non-statutory. These are not mentioned under any law, but they are. That one is a de facto director. Okay, non-statutory. The first one is known as a de facto director. A de facto director is a type of director who is effectively occupying the office of a director. Who is effectively occupying the office of the director. How? When you look at the Companies Act, when you look at Table A, Article 90, Article 90 under Table A, okay? When you look at Article 91, talks about what called rotation of directors. So what does this means that, okay, Article 91. So this means that all directors should retire from office at the end of each and every year. Table A. Okay, so if the director doesn't retire from office, this clearly means that he or she is defectively occupying that office. Okay, on a de facto, yes, on a de facto director. Article 91, Table A. Okay, then if not a de facto director, we shall have what we call de jure director. Okay, yes, DEJURE, de jure director. De jure is a French word which means jury. Okay, so this means a de jure director is a director who is jury appointed. Okay. So the simplest way of appreciating this, de jure, okay, is someone who is legally married. Okay. Then de facto, cohabiting. Okay. That's this. So for you to become de jure, you should be legally recognized. So de facto, you are not recognized as okay, non-existence. Okay, so are we together now? After you've appreciated, yes, counsel. Okay, now after appreciating the different, counsel, type in the chat room. Okay, after appreciating the different types of directors,
Mika, please mute.
Counsel Grace, hold on a little bit. Okay, then after you appreciating the different types of directors, ask yourself, how do we appoint directors? That will take you to appointment of directors. Okay, the word de jure, counsel, is D. Okay, it's simple. It can, you write de jure in Uganda. Okay, so when for us we are reading it, we read it de jure. We who did French. Okay, bonjour. Okay, okay, so okay, so when you are dealing with appointment of directors, first things first, ask yourself, how many directors are supposed to be appointed? Number of directors. Okay, these we are going to just outline for interest of time. Okay, okay, number of directors. When you read the law, says that in a private company should at least have one director. So when they can ask you, what is the maximum number of directors in a private company? What's the maximum? Directors. So the law doesn't give the maximum number. It gives the minimum. So the minimum number should be 1. Okay. Then in a public company, the minimum number should be 2 directors. Okay. So now, after you appreciating that, okay, the number of directors, then ask yourself, how do we appoint them? When it comes to appointment, we have 2 ways of appointing directors. Okay. The first one is appointment of first directors, and the second one, appointment of subsequent directors. Okay. Which article talks about appointment of first directors? It is in Table A of the Companies Act. Okay. First directors. Okay. When you look at Article 75 of the Companies Act, says that the first directors shall be appointed by the subscribers to the memorandum. So that means when we are coming up with a memorandum, the persons who subscribe, we nominate only one person. That person becomes a director. So when that person becomes a director, he or she is supposed to occupy the office of a director for a period of one year. That's why you have Article what talks about rotation. Okay. So then after that, after the 1 year, the first director will retire from office, and then we appoint what we call subsequent directors. Yes. One is now in the board. One of the visual. Okay, so are we together? So once this director, the first director, has been appointed by the subscribers and he has occupied office for 1 year, he will retire from office, and then we appoint what we call subsequent directors. So subsequent directors are appointed in what we call the annual general meeting. Okay, the annual general meeting. Okay, so now, okay, now after the director has been appointed, this person is going to assume office. So then ask yourself, what are the duties of the director? Okay, what are the duties of the director? Okay, what are the duties of the director? Okay, duties of a director are under one provision known as section 197. So you just read section 197, which gives you the duties of the directors. Okay, we have 198, 197, so it has different duties. Okay, now after you've appointed these directors, you've given them duties. Okay. 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 So then, after getting the duties of this director, ask yourself, does the director work alone? Then you go to another person who helps the director in management, known as the secretary. Known as the secretary. Okay. Known as the secretary. Okay. Okay. Powers are not the same as duties cancel. Powers are discretionary, duties are mandatory. Duties, they have the word shall in the act. Powers, they have the word may. We shall deal with that. Okay. So after the secretary, another person who does the management, we have shareholders and members. Okay. Secretaries, we have different provisions. We have section 187. Okay. 187. Okay. After looking at the secretary, okay, We have another person who does the management, which is referred to as shareholders and members. To appreciate that, we shall read section 47 of the Companies Act together with the case of Olive Chigongo versus Mousa Courts, Olive Chigongo versus Mousa Courts, and the famous case of Matthew Rukikaire versus Incafex. Okay? Matthew Rukikaire versus Incafex. Colleagues, I warn you in advance, that is a rich question in orals. Okay? Incafex. Okay? It is a rich case. So read that case so that they always ask counsel, differentiate between the case of Incafex and Matthew. Okay? Then differentiate it from Olive Chigongo versus Mousa Courts. So read those two cases in their entirety, inshallah. So now, after you've looked at those guys who do the management of a company, the presumption is the shareholders are okay, the directors, the secretaries, they are all around. Then we shall go to what we call dispatch of business. So that is today's work. Okay? No. Oh, the last, okay, on those guys who do management, add on auditors. Okay? Add on auditors. So now, briefly, okay, briefly, that was first term's work. I know I've been a little bit speedy, but I was trying to beat time. Okay? So briefly, that was first term work. Okay? I had to draw that line until at that point, because I gave you the stages of a transaction. So our work today, your workshop, is at the stage of dispatch of business. So that's where we are starting from today. So let me give you a breathing space of 5 minutes. Okay? So we are going now to deal with the workshop. Okay? Babuze speed, eh? Okay, maybe as we are switching to our workshop today, I'll do the introduction for the workshop as well. Please mark that our YouTube page is known as the Legal Insight Uganda. Okay. This recording will be uploaded on the YouTube page tonight. So in case you missed this, you can access it our YouTube channel. Okay. So don't forget to subscribe, like, and watch, inshallah. Okay. So it will be uploaded tonight or tomorrow morning. Okay. But it's going to be on for your own consumption. It's called the Legal Insight Uganda by Rashid. It's going to be an interactive channel where all course units, the way we are having them here, we are intending also to have a chat with some of the PAs on how to pass these units that seem a little bit complicated. Okay? Because all we need is to leave the back course and we get out. So we have to utilize all the different avenues to make it good for us. Okay? Because this is the generation of distant learning. So we have to utilize all the opportunities. You will see out there other discussion groups are there. Okay? You'll see last year people came when they are selling those audios. Someone was selling the audio recording at 20,000. 20. Okay. So you could line up
After God fear LDC.
so don't worry, okay? We shall pass. We shall use all the avenues to pass. Those who have just joined us, I see colleagues from Leader, though they are my former friends, are taken long without seeing them, seeing Lincoln and others. So colleagues, don't get scared. We are a very friendly group. We are so welcoming and charming, okay? Nothing can separate the two of us. So let us sound our workshop, okay? Yes, I cancel that page is locked as of now, okay? For security purposes, but it's going to be unlocked tonight, okay? So we are dealing with our workshop now. Let us get our workshop, okay? Okay, let us get our workshops, we get on board, okay? As I've always made it a point, whenever you are reading a workshop, okay, you basically look at the learning outcomes, okay? Attendance, okay, of dealing with
But cancel, your network keeps skipping, so I don't really know how we are going to proceed. The network keeps skipping.
okay? So I'll come back, cancel, okay? We've said that since we are zeroing down to our workshop, it is always a prudent practice whenever you get your workshop, okay? Make sure you know what you are going to deal with. If you don't know, make it a point, okay, to read the learning outcomes, okay? Why? Okay? These learning outcomes, they make you understand the entire workshop. Don't rush to read the facts. You will kutomera for no good reason. Okay? Don't rush to read the facts. Okay? Why? I've always told you that at LDC, they teach applicability of the law. Don't read the facts when you don't know the law upon which you are going to apply them. Okay? It's like buying clothes for the baby even when you are not engaged. Okay? You're not in any relationship, but you want to buy over Nazara Muwala, over Mulenz. Okay? From Sajja, God will tell you, start shopping. You are wasting time. Okay? So when you are dealing with the workshop, first look at the learning outcomes. The learning outcomes are going to guide you on the type of the law you're supposed to address yourself to. So when it comes our learning outcomes, okay? Council kindly share the screen of the learning outcomes if possible. Okay? So anyone with the workshop with us, Council Vanessa, are you in possession of your workshop?
Council, I have.
Okay. Kindly take us the learning outcomes.
Okay, learning outcomes. By the end of this workshop, you should be able to, 1, appreciate the statutory role of directors and company secretary in enforcing corporate compliance and management as enshrined under the Companies Act 2012. Draft various
Yes.
documents and fill in. Draft various documents and fill in the necessary statutory forms relating to management of a company.
So now,
Learning outcome
when you
2.
look at your first learning outcome, Council, hold on, eh? When you look at the first learning outcome, it says that appreciate the statutory role of directors. A statutory role they are referring to, is it a duty or a power? They are referring to a power. Statutory role, something that a role play. Role play is volunteer. Okay. Why? It has a may. So literally, they are telling you that look at how the directors do some of the management. Okay. Then they are telling you for effective management enforcement, you will be required to draft some forms. We shall tell. Okay. Council, let's go to our next learning outcome.
Learning outcome 2. Draft the statutory documents required to convene and conduct board and general meetings of a company.
You see, that's what we call now. They are telling you that you have to also look at what we call general and board meetings. So that means this question requires also you to look at meetings. Okay. Let's proceed.
Learning outcome 3. Explain the different sources of corporate finance.
Now, when you look at how I was explaining these units, okay, upon incorporation, a company becomes an artificial person. Okay, when you are a newborn, you don't spend, not so. But once you reach that funny stage of spending, buying everything around Kampala, you run broke. So that's what we call dispatch of business. You seeing a phone, you want to get it. You seeing land, you want to get it. You're also trying to dispatch business so that you can survive. Same applies to the company. Once it starts dispatching business, holding meetings, passing resolutions, the company runs. You know, attending those meetings, one of the best. You go as a legal advisor, you eat peanuts, eat bread, okay? They bring those huge flasks of tea, you enjoy tea, unlimited tea, okay? That is all spending. So from that process of spending, some meetings don't yield anything, okay? Some meetings are convened to borrow. So from those dispatches, the company loses a lot of, it runs broke. That's why we go for to call corporate financing. Corporate financing means financing a company because the company is a corporate entity. We shall appreciate that. Okay. Council, proceed.
Learning outcome 4. Understand the statutory corporate procedures related to calls on shares, preemption, and forfeiture.
Okay. So now, when you look at making a call on shares, it is making a demand. One of the mandatory filings we looked at was known as a return on allotment. A return on allotment shows that upon incorporation, our company has a share capital of 5 million shillings divided into 500 shares, each costing 10,000. So upon incorporation, Joan has agreed to take 10 shares. Mercy has agreed to take 20. Okay. Anita has agreed to take 5. However, Joan has paid for 2. Anita has not yet paid a single coin. Mass has paid all her. So that return is like a report on how many shares have been allotted and paid for. So as a result of that, if we have people who have not paid, we make a call. Kindly pay. So making a call is making a demand for you to pay. We shall get there. We shall get there. That's what we call forfeiture. Okay. Yes. Okay. Comes another learning outcome.
Learning outcome number 5, address challenges in respect of corporate management, specifically enforcement of shareholder / member statutory rights.
Okay. So then identify ethical issues disclosed above. So now, after reading those learning outcomes, you see where they are pointing you. They are pointing you to meetings and corporate financing. So that means one of your workshop is on meetings and another workshop is on corporate financing. So that means when I'm reading the Companies Act, I will zero down to the laws that provide for that. Just all kusoma Companies Act, says you're not good. Okay, even us reading it was a tug of war. Me, this time it wasn't there. It came after this. Okay, so now let's get to the law. Okay, so I'm going to be giving you different sections randomly. Why? Our modus operandi, we first read the law. After reading the law, when you refer to the facts, you say, okay, now I know. Okay, so let's get to the law now. The section who is in possession of the Companies Act, those who are online.
I have one, Council.
Okay. Council, is it amended? I want to be sure because I don't want to cite wrong law.
I have the amendment too.
I also have the amended one.
So whenever I say a section, you first check.
Much obliged, Council.
Okay. Wait. Okay. So today I want us to first deal basically with workshop 1. So I'm going to be giving you sections. Or you just rush to the section. Okay. Then after, when you read the facts, you will just give the answers yourself, even me without giving you answers. Okay. Council, take us to section 140. So there's provisions we are looking at. Laws governing meetings. Okay. Laws governing meetings. Okay. So let's, Council, take us section 140.
Length of notice for calling meetings. I read through?
Yes.
Okay. Subsection 1.
Yes, read, Council.
Any provision of a company's articles shall be void insofar as it provides for the calling of a meeting of the company other than an adjourned meeting by a shorter notice than 21 days. Subsection 2.
Okay.
The notice
so what does that mean? That, okay, that all meetings of a company are called by a notice. Okay. But the notice is divided into 2. We have what we call a general notice and a special notice. Okay. So it is upon you to ask yourself, the facts before me require which type of notice? So the notice Cass has just read is what we call the ordinary stock general notice. Reason, an ordinary notice is a notice which is issued within 21 days. So below 21 days, it becomes a special notice. Okay, within 21 days. So below 21, it becomes a special notice. Let's go on. Council, proceed.
I beg your pardon on that, Council.
Council, we are losing you vehemently.
Yes? I beg your pardon. I beg your pardon on this ordinary, the explanation of those notices.
Okay, we've said that an ordinary notice is a notice of 21 days. So below 21 days, it will be referred to as a special notice. Okay.
Okay, Council. Subsection
then Council
2.
Proceed. Yes.
The notice under subsection 1 shall be in writing. Subsection 3, except where the articles of a company may make other provision, not being a provision declared to be void for the purpose by subsection 1, a meeting of the company other than an adjourned meeting may be called by 21 days notice in writing. Subsection 4.
Okay. So you sure what that means? Okay. That you unless, that's what has unless. So that means the memorandum and articles, they should specify that in the following circumstances we shall issue a notice below 21 days. But that's not what we need. Okay. So Council, take us to section 141 now. We want to see this notice they are referring to in section 140. What are the contents of that notice? How should it be structured? Council, take us to section 141.
Okay, general provisions as to meetings and votes. The following provisions shall have effect insofar as the articles of the company do not make other provision for the purpose. A, notice of the meeting of a company shall be served on every member of the company in the manner in which notices are required to be served by table A. And for the purpose of this paragraph, the expression table A means that table as for the time being in force. B, two or more members.
Now,
two or more members holding not less than 1/10 of the issued share capital, or if the company has not a share capital not less than 5% in number of the members of the company, may call a meeting. C, in the case of a private company, 2 members, and in the case of any other company,
okay, no,
3
Council, stop there. Okay, stop there. Okay, when you go deep in that section, it provides that 1, a notice should include the time of the meeting. Okay, should include time of the meeting. 2, should include the venue, the time of the meeting. Then 2, should include the venue. Okay. Should include the venue. Okay. Then 3, okay, should include type of resolution required. Then date when the meeting is going to take place. Okay. Then lastly, type of business to be dispatched. Mugenda kwogera ku ki. Okay. Okay. So now, the presumption is you've issued that notice. Okay. but the notice is calling for what meeting? Types of meetings. You'll later appreciate why we are reading these sections. Okay, types of meetings. Okay, so the first type of meeting is known as a statutory meeting. Okay, one of the mandatory filings, we have what we call a statutory report. So yes, types of meetings. Council, take us to section 137. Statutory meeting 137.
Okay. Statutory meeting 137. Subsection 1. A company
So let me
limited by
read. Let me read. Okay.
Okay.
It says a company limited by shares and every company limited by guarantee and having a share capital within a period of not less than 1 month or more than 3 months from the date which the company is entitled to commence business shall hold a general meeting known as the statutory meeting. So that meeting is mandatory. Okay, that's what is called statutory. Something statutory, it is mandatory to be done. Why? The section uses the word shall. Okay, it uses the word shall. Okay, uses the word shall. Then another type of meeting, we have the annual general meeting. Council, take us to 138 if your network is stable.
Okay. Yes. Annual general meeting, section 138.
Yes.
Subsection 1. A public company. Should I proceed with this, or I should proceed with subsection 2 for private company?
No, now, can I first read?
Okay. A public company shall in each year hold a general meeting in addition to any other meetings in that year, and shall specify the meeting as general meeting in the notices calling it, and not more than 15 months shall elapse between the date of one annual general meeting of a company and that of the next. Subsection 2.
So what this provision says, in a public company, it is mandatory to have the annual general meeting. But read subsection 2, Council.
A private company may, at the requisition of a member, hold an annual general meeting.
So they can ask in orals, what meetings are mandatory in a private company? So the annual general meeting is not mandatory. It may or it may not be convened. So it will take upon your emphasis. But remember, see, this flow is fun. It is not mandatory, it is upon requisition in a private company. But remember, you have to appoint directors. When they remain, they will be de facto. So by all means, it is mandatory. The act is silver neta. Okay. Then Council, take us to another type of meeting, what we call extraordinary meeting under 139.
139. Okay.
Yes.
Subsection 1. The directors of a company
Council.
Subsection 1.
139 says convening of an extraordinary general meeting on requisition.
Yes.
Says that the directors of a company, notwithstanding anything, okay, notwithstanding anything in its articles, shall on requisition of members holding not less than 1/10 of the paid up capital of the company as at the date of deposit carries the right of voting at the general meeting of the company, or in case of A company having a share capital, members of the company representing not less than 1/10 may convene the extraordinary meeting of the company. What does this mean? That an extraordinary meeting, okay, is a meeting that is convened, okay, that is convened by a company on requisition of a member, and besides that, not everyone can make that requisition. Okay. Not everyone can make that requisition. So yes, the law has limited people, okay, those who have a particular percentage. Your predecessors of 2020, 2021, they did a paper on this. It was hard, unless you know. They told them how to beat this, how to oppose this application. Imagine. And the ground was you've not paid a tenth of the shares you do. But getting it at that time is a miracle. Okay, so we proceed, council. Then another type of meeting. Another type of meeting. Another type of meeting. We have what we call court-ordered meetings. Court-ordered meetings. Okay. Council, go to section 142.
Okay. Power of the court to order a meeting. Subsection 1.
Yes.
Where for any reason is impracticable.
Yes, council, we proceed.
Where for any reason it is impracticable to call a meeting of a company in any manner in which meetings of that company may be called, or conduct the meeting of the company in the manner prescribed by the articles or this act, the court may of its own motion or on the application of any director of the company or of any member of the company who would be entitled to vote at the meeting, or the meeting of the company to be called, held, and conducted in the manner the court thinks fit.
Now, an example. This happened in COVID, where companies could not meet physically, okay? But they had to hold meetings. But their memorandum and articles didn't provide for that. So what happened? We happened to have had a matter with Justice Second, okay, where one of the companies made an application for a saturation meeting, okay? A saturation meeting is a meeting which is held other than the ordinary model. So these guys made an application to hold a meeting online, virtual. That's how companies started using Zoom, because of the authority from Justice Second. Okay. So these guys, after, when you read subsection 2, says that where court makes an order under this section, it can make such other auxiliary or consequential directions as it deems. So once your articles and memorandum don't disclose the type of meeting, okay, let's assume by Zoom or by Facebook Live, whatever, okay, by Twitter Space, okay. So other what we call consequential orders. Remember, your articles should reflect. They can also give you an order to amend the memorandum so that you include it, okay. That's why we have subsection 2. Okay, those are what we call court-ordered meetings. Okay, now after the meeting has been convened, we have, yes, court-ordered meetings where it is not practicable, okay, to convene such a meeting as the memorandum and articles are. You can apply to court to grant you a right, okay, to convene a meeting in any other way. That's what we call court-ordered meetings. Okay. Okay. We go on. Then another type of meeting, we have what we call board meetings. Board meetings. Okay. So tugenda kukisusaamuko. For certain reasons, you're going to see board meetings. Okay. So a board meeting, this is a meeting that is convened by the directors of a company. Okay. A board meeting is a meeting convened by the directors of the company. Okay. We have council take us to Article 98 of Table A. I doubt. Council open first Article 98. Mine is on soft copies of okay. But Article 98 says that the directors of a company may, from time to time, meet and dispatch business of the company. So that is the law that gives you powers as directors to meet and dispatch business of a company. Okay. Are we there? Have we seen it, members? Okay. So now, okay, Article 98, proceedings of directors. The directors may meet together for dispatch of business, adjourn and otherwise regulate their meetings. So you see, the wording of this gives you what we call board meetings. So now, at that very point, before we leave that, ask yourself, what type of business is dispatched by the directors? I have reasons why, because I'm summarizing basically the workshop on it. Okay. The first type of business that is under the body meeting is known as making a call on unpaid up shares. Making a call on unpaid up shares. Making a call on unpaid up shares. Okay. Council, take us to Article 15, Table A. Article 15, Table A. Council, take us there, or I take you there. Okay. Article 15, Table A. It is
there,
to the
Council.
effect that, yes, take us.
The directors may from time to time make calls upon the members in respect of it, or any monies unpaid on their shares, whether on account of the nominal value of the shares or by way of premium, and not by the conditions of allotment of the shares made payable at fixed times. Sub-Article 2, a call shall not exceed 1/4 of the nominal value of the shares.
Council, first wait. I told you, if you want to understand that this work is done by the director, the section says itself. It says that the directors may from time to time make calls on. So if we demand you, it is the director to make it, not so. So that means that business is dealt with in. Now, let's go to the process of making a call. Process of making a call. How do directors make a call? Okay. How do directors make a call?
Said you can always mute when you're not reading anything. You're really killing our ears. Mute when you're required to read and mute. Now kindly admit some people in the waiting room. People are inboxing them.
Okay, so colleagues have been off, network had thrown me out. So we were talking about how to make a call. Okay, so when you read Article 15, it says that the directors may. So what does that mean? I want to look at the word the directors. What does that mean? Which type of meeting is that? It's a board. So can you go in a meeting without issuing a notice? So the first thing is issuance of a notice calling for a board meeting. Okay. So the first thing is issuance of a notice calling for a board meeting. Okay. Then after that, we shall say passing a resolution to make a call. To making a call. Okay. Okay. So we've said the first one is issuing a notice, then passing a resolution, making a call. Okay. Then after passing a resolution, you put a note, conditions for making. You cannot make a call just for. Okay. The law has set conditions for making a call. To make a call. Okay. Then we go to conditions to make a call on the unpaid up shares. You can't just make a call anyhow. Okay. Council take us to okay, on shares. Okay, the conditions. Okay. On shares or unpaid shares? Unpaid up. Okay. So Council, let's go to 15.2.
Okay.
15, yes. Article 15, clause 2.
Okay, a call shall not exceed 1/4 of the nominal value of the share or be payable less than 1 month from the date fixed for the payment of the last preceding call.
So what does that mean? Okay. that even if I'm demanding her shares worth 1 billion, I should demand for a quarter only. Okay? If she took okay, what that means that a call doesn't exceed a quarter of the shares you are demanding. Shares, okay, making a call for a quarter of 10, a quarter of the shares demanded. Okay, now let's assume we've agreed to make a call on a quarter. Okay, the next step is issuance of a demand notice. No, this is not a condition. Now this is a step. It's our third. After the first payment, depending on how you have specified, we are going to see the notice. Okay. The first step was calling for a notice, calling for a board meeting, passing a resolution. Okay. So we've passed the resolution and we've complied with Article 15 Clause 2. Now we want to look at our third step. Okay. That is issuance of a demand notice. Okay. Council, go to Clause 3.
Okay.
Yes, 15.3.
Each member shall subject to receiving at least 14 days notice specifying the time and the place of payment paid to the company at the time and place specified, the amount called on his or her shares.
So what does that mean? That the demand notice, its contents are under 3. 1, it is of how many days? 14 days. Okay. Section Article 15.3. Okay. 1. Article Council. Okay. It is a notice of 14 days, including the following: 1, the amount he or she is supposed to pay. Yes, it's a demand notice. Okay, so it includes 1, the amount he or she is supposed to pay. Then 2, time of payment. Okay, 1, time of payment, amount to be paid, date of payment, and where. Time of payment and where it to be paid. Okay. Okay. Now, let's assume the notice has been issued. It specifies the time, when and how much, and you don't pay on that time. Someone asked that question. If you don't, what happens? Okay. If you don't pay, the next step will be issuing of a reminder notice. That is the fourth step. Issuing of a reminder notice with an increment. With an increment. With an increment of 5%. Ntikota sasudde ennaku z'omwezi nga zino ojja kusasula bweziti naye oyongeremu ebitundu 5 ku buli 100. Okay. Council, take us to Article 18.
If a sum,
Okay, yes.
If a sum called in respect of a share is not paid before or on the day appointed for its payment, The person from whom the sum is due shall pay interest on the sum from the day appointed for payment of the sum to the time of actual payment at such a rate not exceeding 5% per year, as the directors may determine. But the directors may waive payment of such interest wholly or in part.
Okay, so we've seen our second notice. Yes. So now, let's assume this fool has been given that notice as well, but has refused to pay. Okay. So what happens on non-payment? Council, take us to 19.2.
Okay. In case of non-payment, all the relevant, in case of non-payment, all the relevant provisions of these regulations as to payment of interest and expenses, forfeiture, or otherwise, shall apply as if the sum referred to
even if we stop there. So that means upon non-payment, we shall call forfeiture.
After a reminder, he does not again.
Yes, then we proceed under Article 19, Clause 2, and we do forfeit the shares. Forfeiture. Forfeiture of shares as a company. So now I know one learning outcome has been covered. I'm very sure. Yes. So now I have the shares. Okay, it's called forfeiture of shares. So now, yes. Okay.
So there, here to remind that it takes how long, how many days? Because the issuance of minutes.
Setting up case. Yes. That one is discretionary. Was in a right first notice on a warm speed. Yes. Okay. So now I'm telling you, okay, in orals, I have a colleague who has asked counsel, at what stage does someone cease to be a shareholder? Okay. At what stage does someone cease to be a shareholder? It's a question. It was in orals. Counsel Johan, at what stage does one cease to be a shareholder? When yes, members, where did we stop? Where did you stop hearing?
We are going to forfeiture of shares.
Kindly notify me, we resume.
It was under Article 19.2 where we stated that if there is non-payment after the last reminder, then they forfeit the shares of that person.
Okay, so we've said that after the last reminder, where there is no payment still, okay, we shall proceed and do what we call forfeiture of shares. Okay, so we forfeit these unpaid up shares. Once we forfeit them, we gain momentum. Okay.
Counsel, we can't hear you.
We are using this gadget. Yes? Yeah, 1 minute. Okay, we are using this gadget. Okay, so I was saying that after the last reminder upon non-payment, we do what we call forfeiture of shares. Once we do forfeiture, we retain back our shares. I was giving an example that let's assume Joan has a boutique and Marcy comes around and she likes a dress and she does part payment. However, all efforts to contact Marcy have been rendered nugatory. Okay, so as a result of that, at the end of the day, we are able to appreciate where Marcy is hiding. Okay, after understanding where she's hiding, natugamba mwe mumanyi China sente mbadde mulwadde. So you're going to keep the same dress. So then what you do, you tell her, come for your car 20K. I sell my dress. So that refund and taking of the dress is what we call forfeiture. So now after forfeiting, you own the shares. And we all know under Section 83 of the Companies Act that shares are transferable property. Okay? So as a result of that, ask yourself, what are the different ways through which one can deal with his or her shares? Okay? Different ways through which one can deal with his or her shares. Okay? So now, Councillor Daniel, kindly proceed. So how we can deal with your shares is what we call issuance of shares. So these shares can be issued at a premium, can be issued at a discount, can be issued as redeemable preference shares or nominal shares. Premium, discount. So we are going to look at them, okay? Council Aisha, kindly make me a co-host, okay? So, Council, take us to section 66. The first one we are looking at, issuance of shares at a premium. But as I told you, okay, so when you look at section 66, it says application of premiums received on issue of shares. What? 66. So that brings in what we call issuance of shares at a premium. But you can't understand unless you know what amounts to a premium. Okay? Yes. Okay? So a premium a premium is a difference between the nominal share capital value, between the nominal capital share value, okay, the nominal share capital value and the amount sold. What does this mean? If the ordinary share of a company, okay, is 10,000, issuance of a share at a premium, we shall share that share at 50,000. Have you ever had a friend You know the price of a towel is 20K, but when your colleague sells that towel at 60K, no gain, okay? But because you don't have an option, you have to buy, okay? So this is what happens. You know the exact truth that the amount, okay? The amount of the share is 10,000. But because we need money, we shall sell that share at a premium. We shall put it at, so a premium is the profit margin that you make upon selling shares at that amount. Yes, the profit margin made on selling of those shares. Okay, so now, Council, read the section now.
Okay. Subsection 1, that is section
Yes.
66, subsection 1.
Okay.
Where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount of value of the premiums on those shares shall be transferred to an account to be called the share premium account. And the
What does that, hold on, Council. What does that mean? That when you sell shares at a premium, whatever profit you make, you have to put it to a premium account. So when you are intending to sell shares at a premium, okay, you create what called a premium account. Or you know, got a kawa at the end of the day to galabeko. Okay, selling shares at a premium is selling a share, okay, above the nominal share capital. Okay, the share the nominal value is 10,000. So you selling that share slightly above is what we call selling shares at a premium.
Wait, selling a share above the
Yes. Shares at a premium. Okay, made upon selling. If not, we can say a premium is a profit margin made upon selling a share beyond the nominal share value. Okay, that's what we call the premium. Okay, made upon selling shares beyond the nominal share value. Okay, so that's what we call issuance of shares at a premium. Then, if not a premium, we can sell shares at a discount. So the second way of selling shares is shares at a discount. A discount is below. Yes? Okay? We are going there. Selling shares at a discount is selling below the nominal share value. Our share is 10,000. And for us, we sell it at 7,000. To what call our profits? We are making losses. So as a result of that, the law is a bit strict on issuance of shares at a discount. Why? The law doesn't allow a company to make shares, to make losses. So when you read the section, it has some stringent terms. Okay? Section 67 of the Companies Act says that subject to this section, a company may issue at a discount shares in the company of a class already issued, except, what does this mean? That the first condition, shares at a discount are issued only to members who have already been issued shares. Okay? Shares at a discount, the first thing is, are issued to members who have already been issued shares. Why? Mugende wa mukwano gwo n'atunda tawero 200K. Nga bwenda abagulenge wa Brands. Naguza t-shirt emitwalo 3. Okay, so after knowing that in one night, wallahi Joan mukubyeko, but the Joan akasika belt na kwewesa ka belt later kakwade kubwere no hajat what you can do engage of 10 abaya kumitwala asatu kano ka dress kakumi osobola okumpa omukaaga. You see, she's telling you that the dress is at 100K, but because you've bought akimanya kubye, the right amount of the abaya is 100K, but she has sold it to you at 150 tagabanai. Chikwano change kino kiyinza obutadda. Okay, so what she does, but I don't dress one to take kale eriko 10 naye engeri gy'oli gwe wanga ate ompagidde. Okay, why? Now she's selling this one at a discount. Why? She's selling it to a member who has already bought something. So what happens? Someone who buys a share at a premium, wallahi yaba muzira. Kiringa kugamba abewaabwe basezi. Noga nayinja mwagala. Oba basezi. Okay? So what does that mean? A person who buys shares at a premium is given a bonus. Which bonus? He's given other shares at a discount. That's how it applies. Okay? Okay? Shares at a discount are given to members who have already been issued. Why? Why do we give these guys shares at a discount? That's the essence. Okay? That's the essence. To convince them. Okay? Yes, Kans. That's what companies do. Okay? Yes, that's what companies do in practice. Okay? Then another condition to issue shares at a discount. When you proceed by the section says that the issue of the shares must be authorized by a resolution. So the entire company has to see it. Okay? Yes. Okay? Must be approved by a resolution. When you look at this, the section doesn't provide exactly which type of resolution. But whenever you are reading the law and the law doesn't specify which type of resolution, you proceed by an ordinary resolution. Okay? Are we together? Then when you proceed with the same section, it says that it should also be endorsed by court. So you should also have a court order. Why? Issuing of shares at a discount, it makes a company makes losses. So we have to fight so that our company gets there. Okay? Are we together? Yes. Yes. Okay. Should be endorsed by court. The resolution. Yes. You know, a court order. The court here to that we shares at a discount.
To those members who have already acquired.
Yes, because it is going to infringe on rights of other members. So these guys may bring a complaint under force versus saboteur. Okay? Okay? So then the third mode of issuing shares is known as issuance of redeemable preference shares. Issuance of redeemable preference shares. In our simple English, the word redeemable means something you can gain back. Okay? Something you can gain back. Okay? Now, it has issuance of redeemable preference shares. Preferential shares. We have redeem and the preference. Preference is giving someone an extra treatment. Okay? Okisusaamu. Why? Bw'owasa omukyalo omulungi ng'ate olina ku ssente, bwe mugenda mu kyalo, she will be given what we call preferential treatment. Ajja sala zi akole ne juice. Okay? Kati gwe bw'oba nga Mungu yakugerera akasente katono ate n'ogenda oleeta Namamonde alina okugenderera kutesa piki akume mu kyoto. You see? So why do we have redeemable preference shares? When the company is in their need of money, company ebeeramu abo abalinamu kuki ya musiraamu. These are just for example purposes. Okay, so as a result of that, this person who comes out nagamba nze mbawadde. Okay, once someone gives a company money, this person is borrowing. Okay, but every borrowing needs security. So this guy is the company, because you are borrowing the company, not the directors. So the company will get on its shares and they give you as security. Okay, and you give them money. Okay, so you will stay with these shares, but when these shares are redeemable, when the company pays you back, it takes back its shares. Okay, because you have taken that extra step to give the company money, we shall give you what we call preferential treatment. How? Tusobola okugamba buli share erimu shares omeka biri. You know you know when someone wants to borrow money, the way they can, mama, they kusudia zenkonjazi za mwiki biri ate kale just kuwalira nani kutedemu emitwalo abiri ngera kutera mwaga n'obuguma n'owa Vincent sente kumbe tasasula. You see? Okay, so that's what called the preferential. So once the company has, you've given the company money, okay, and the company has given you shares as security. Okay, so what happens? Because you have taken that step, omuntu yenna akujja mu buzibu omusiiga akazigo. So that's what the company does. Okay, they give you that preferential treatment. Why? You have to kusukuluma on other shareholders. As I've been seeing a meme on WhatsApp, n'omusajja akuwa ku sente mu January yeetaaga kola ki wali ku State Square. That preferential treatment, because January tuli mu January Pro Max. Okay, tuli mu mwezi ogwokubiri gwe January omutaba sente omulaba talina.
Not him.
Okay, you get it. That's what called preferential. So these redeemable shares, the company can at any time gain them back. That's why they're called redeemable preferential shares. But upon giving you these shares, you can't just redeem. Okay, so the law has put conditions for the company to be able to redeem its shares back. Okay, Council Daniel, proceed with the same section. It is going to show you the conditions upon which redeemable preference shares can be issued. Okay?
Okay.
Subsection 2.
Okay. A share shall, okay. Subsection 1 is subject to the following. A.
So what does that mean? That for you to redeem the shares, the following conditions should be fulfilled. Council 1.
Shares shall not be redeemed except out of profits of the company.
So what does that mean? That the first thing you need to prove that the money we gave you, you've made profits. Okay? Okay? So it's 68. Okay? It is section 68. Okay? So the first condition, you're not going to come, you get our shares as it were. Sente ze twakuwa zikoze amagoba. So you first show us, we who borrowed you money, that we've made profits. Okay? Yes, that's the first correlation. That you've made profits out of the money we borrowed you. Yes. That's what we call shareholders loans. Yes. Has made profits. Okay. No. Once you issue me with shares as redeemable preference shares, the moment the company wants the shares back from me, it has to prove to me that it has made profits.
Who has made profits?
Okay, the company. Okay. It's like this. You've borrowed your company money. Let's assume you are a shareholder as it is. Okay, in National Water and Sewage Corporation. Okay. We have recently some people bought shares in MTN. Okay, you are a shareholder in MTN. Okay, so you being a shareholder in MTN gets some financial problems. Never can have a shareholder providing go best chala ruama tutase yo nakawumbi kamu tujja kaza no bagamba mba wakawumbi naye mumpachi nagamba tulinayo shares eyo shares 10 tugenda kusingira shares zino but tuza sente ng'otuwachi shares. So remember now you are a shareholder bakwongeddeko kuki, so that means ogenda kuofuna amagoba ga mirundi egi ekitegedde. Kati company bwebe eyagala okutwala shares zino zekusingidde olina okukakasa the sente ze wagiwa akawumbi ekozemu profits. Bweba tenakola profits they don't redeem. Yeyina okukakasa, it has to prove that it made profits. If they made losses, the shares zisigazi paka nga bakoze amagoba sente ye erina okuzaala. The law of company is not easy. Okay, so council, proceed to another condition.
The shares shall not be redeemed unless they are fully paid.
Now let me tell you, some people who deal with by name maybe. Why? What happens if someone knows that I don't want to take these shares back? They refuse to pay. Remember, you can take them without national government. Okay, so never shares worth $1 billion, but you give them just 700 million shillings. So that means you have what we call unpaid up shares. So when they want to redeem, you have to first pay the balance. Okay, if you don't pay, they don't take them. So what's up? Because remember, you are enjoying benefits. Okay. Yes, it's the way of maintaining shares. Some people refuse to pay so that they make a company make losses as they are earning out of them. Okay, are we together? Cancel another condition. Okay, that
B,
the company, they should be paid up the shares.
B, the premium, if any, payable on redemption must have been provided for out of the profits of the company or out of the company's share premium account before the shares are redeemed.
Now, if you've not made profits, okay, you should have shares at a premium. Remember, we saw a premium account. So you go on the premium account, you get money and pay. You get it? So you should have a premium account as well. It's another condition. The company should be having a premium account. That in case you don't make profits, you have a premium account which has some money. Okay? Yes. Yes. Account. Okay, a premium account. You go to the premium account, no Jayo, no Sasula. Okay.
What I'm saying, okay, we have that premium account.
Oyinza okuba tokoze osinga okuba tokoze profits seboogerako wano waggulu naye bw'oba tokoze profits olina okuba nga olina premium account ebeerako magoba g'okola mu kutunda ki shares kati ng'ojja eno ng'ate osasula eno. Okay, so that another condition that in case you've not made profits, you should be in possession of an active premium account. Okay, yes, you go to the premium account and get money. Okay, you don't redeem. Okay,
So we didn't hear that point. Your network went off.
yes, cancel.
We didn't hear that point. Your network broke.
We've said that the last condition is that a company should also have a premium account. Okay?
You're off again. You're off
Council,
again.
take us to Article 79. Okay, so now, whatever we've been seeing, that is known as equity financing. I'm going to explain after reading Article 89. I'm going to give you everything now. I add them to make sense. Okay?
This one is from where?
Okay. No, the modes of issuing shares are done. Okay. The modes of issuing the shares are done. But now we want to see, okay, how things happen. Okay, other than when you have shares. That takes us to what we call external borrowing. So external borrowing, you only read Article 79 Table A. The directors may from time to time borrow. Okay, no. That is external borrowing. These are done. Okay, it's another subtopic, external borrowing. Okay, Article 79 Table A, which says that the directors may from time to time borrow. Okay, the borrowing powers, but not exceeding the share capital of the company. Okay, it is also another mode of getting money in a company. They not saying. Okay, it's about the selling of shares. I don't know. It is also a type of business that is done in a board meeting. Okay, it is known as borrowing. Okay, so now when you, yes, that is the date. That's I'm going to do a general wrap up of these things to make sense. Okay, are we together? Okay, so now another type of business that takes place in a board meeting is known as borrowing. Council, take us to Article 79. So, yes, more. Okay, you can also take out borrowing. So council, let's go to Article 79 Table A.
Okay. Article 79, sub-article 1, the director may exercise all the powers of the company to borrow money and to mortgage or charge.
Now, I want you to underline the conditions for borrowing. The first condition is borrowing is made by directors. That's the first condition. Okay, council proceed with the same provision. It's going to give us the second condition.
To mortgage or charge its undertaking, property or uncalled capital or any part of it, and to issue debentures, debenture stock, and other securities, whether outright or as security for any debt, liability, or obligations of the company or of any third party, except that the amount for the time being remaining undischarged of monies borrowed or secured by the directors, apart from temporary loans obtained from the company's bankers in the ordinary course of business, shall not any time without the previous approval of the company in general meeting exceed the nominal amount of the share capital of the company.
Another condition is the borrowing should not exceed the nominal capital. Okay, that if the company has a capital of 10 million, you can't borrow money exceeding 10 million. Okay, you can't exceed the share capital. Yes, it's the same. Okay, so now I want us to make sense of that work. Okay, before we go to read our facts of workshop 1, as you know that a company upon incorporation, it becomes a person. Okay, in the process of dispatching its business, it loses money. So as a mode of reviving itself, it has to find possible means of getting money. So these modes of getting money, they have a legal term known as corporate financing. Okay, so the legal term corporate financing basically refers to the different processes through which a company acquires money to facilitate itself. Okay, so these are divided into 2. We have what we call equity finance and debt finance. Okay, you know already. Okay, we have what we call equity finance and debt financing. Equity financing is what we call internal borrowing. You use the internal means to get money. Internal means within the company. And these include 1, making a call on shares. We have it, not so? Then after making a call, the second one is issuance, stock allotment of shares. We have it. Okay. Then the third one is what we call shareholders loans. Okay. All those things are within the company. Okay. You've made a call on shares that were unpaid up. Then secondly, you proceed and issue shares so that you can get money. So under issuance of shares, that's when you shall look at what we call allotment of shares at a premium, at a discount, and then redeemable preference shares. So you choose. For you, from what we've read, to be honest, making a call, can you get money if you are relying on making a call? Is it an appropriate mode of making a company get money? Are you sure, Council? You have a problem in your home. Omwana wa alikishitana baga million meka satu. You are demanding Brenda 3 million. Okay? But when you open your argument, you said ntiwemba sina sasula nzikirizibwa kuwako emitwalo 3. Digena kuyamba. So when we go to making a call, we saw the conditions of making a call. The law allows you to make a call on only a quarter. When are you going to get the money to solve the problem? Okay, so you cross out that. It's not appropriate. Are we together? Then you go to the second mode, which is known as issuance of shares. Okay, so on issuance of shares, we have the first way, issuance of shares at a premium. You sell and get profits, not so? Then the second one, issuing shares at a discount. Are you getting money on a discount? Then redeemable preferential shares if you don't make profits. So what is the most appropriate among those ones? Yes? It is issuance of shares at a premium. Okay? Then if not that, you can go for shareholders loans. When you have a rich shareholder who has some money, singular shares as well. Okay? So after exercising all those means, sentence you can proceed and deal with what we call external borrowing. That is borrowing from the bankers of the company and other financial institutions as per Article 79 Table A. Okay? So now, after getting that genesis, let us proceed and read our facts. Okay? You're going to see. It's yourself who is going to be okay with the facts. Yes? Yes. Yes. Okay? External is also known as the debt financing. Yes. So now, cancel. Okay? Let's read our facts now. Okay? Council Daniel, let's read the facts of workshop 1. You're going to tell. You will see that you are there. Okay?
Okay. Upon the incorporation of Namamve New Energy Limited, as was given in the facts of the week of 21st to 25th November 2022, the company started operating business. The company has implemented various projects in the Ministry of Energy.
Council, stop there. First, stop there. What transaction are we dealing with? What transaction? It is a corporate transaction of a company, not so? The transaction is at what stage? Is it management, dispatch of business? Yes?
Dispatch of business.
It is dispatch of business. Okay? From that paragraph, does the transaction of dispatch have a problem or it is fine? It is fine. It has no problem. Council, proceed with another paragraph.
On commencement of business of the company, Young paid 250 million shillings out of the Uganda shillings 500 million.
So that means Young at Mubanja.
Yes, 250 million.
We are demanding Young. The company demands Young. Because upon incorporation, a company becomes a body corporate, which has capacity to own property. Shares are property. So the company owns shares, which it gave to Young. Young had to pay the company how much? 500 million shillings. He paid the company how much? So the company is demanding. You put a note. We proceed.
Okay. Muranda Kasson and Rashid Mpoyoyo each paid 25 million out of the 50 million each promised to invest in.
We also demand those guys, not so? We also demand them, not so?
Yes.
Now, you have do you have the answer or you don't have?
We shall find out.
We proceed, council.
It was agreed. It was agreed that Young, that name, the Chinese national, and Muranga Kasson to be directors of the company, while Nkoyo Rashid shall be a secretary.
Underline Nkoyo to be the secretary. You will see why.
Okay.
Proceed, council.
The trio agreed to all to all actively participate in the running of the company business. Yang will once in a while fly from China into the country to attend company meetings and execute company documents.
So that means Yang is not always on ground. So we have circumstances where he may attend a meeting when he's not in Uganda. We had that saturation meetings to get them muscle.
As a result of the Ebola outbreak, there is a ban on travelers from Uganda.
So stop there. We have dispatch of business. Now it has a problem. Yang can't travel from China to Uganda. The company is in Uganda. So ask yourself, how will they solve that problem? Council, proceed.
Court order.
Okay.
From Uganda entering China. As a result of the above, Yang is worried that it may take a long time for him to come to Uganda, which may greatly affect the company business.
But now you have a solution to that as well, not so? Same as that.
Yes.
To proceed.
In December 2022, the company won a tender with Ministry of Energy to construct several electricity lines to connect several small towns in the Acholi sub-region under the semi-urban electrification program. The tender is worth over 10 billion shillings, Uganda shillings.
Stop there. So the question is, do we have the 10 billion now?
No.
Do we have the 10 billion?
No.
So how are we going to get that money? Then that takes us to what we call council, proceed.
Okay. The company signed a contract with the ministry where it was agreed that the work should commence by the end of February 2023.
Yes.
The directors of the company are worried about raising over 5 billion Uganda shillings
so
needed to start the work.
The company wants money. The company wants 5 billion. Okay. Mods how this company can raise this money. We have what we call equity financing or debt financing. So first, look at equity financing. When our facts were starting, Rashid Tumubanja with his colleagues, they have unpaid up shares. So the answer is making a call. That's the first way of getting money to Bavand. You see, the workshop is very simple. We proceed. Okay? We proceed. I know you guys are tired, but bear with us. Okay? Council, proceed.
Okay. Nkoyoyo Rashid has approached Stanbic Bank.
Stop there. Underline the word Nkoyoyo Rashid.
Yes.
You remember up where I told you that look at Nkoyoyo shall be the secretary?
Yes.
Look at Article 79. Who has the power to borrow? Do secretaries borrow money?
No.
Who has the power to borrow?
Direct.
What principle are they testing here? The Indo management rule, the Takwadi's rule. The presumption is if the law says that the directors may, everything should be done by, so Nkoyoyo has no power to borrow as per the law. So you advise them that Nkoyoyo can't borrow. You see? Corporate is the best cost unit, whether you like it or not. Council, proceed.
Okay. He has approached Stanbic Bank to borrow on behalf of the company at least 2 billion Uganda shillings using the land.
Look, I want you to look at the 2 billion shillings. Unfortunately, you guys don't have, I don't know whether school still recall your workshop. Okay? You come up here. Okay? Add this money. Okay? Add the money. Younger was to pay how much?
250.
No.
That's what we are demanding.
No.
To top up to 500
the entire
million.
sum you were supposed to pay.
500 million.
Then Rashid and the colleague also 500 million?
No, 50 million each.
So that means the company has the share capital of what?
600 million.
These guys want to borrow how much down?
2 billion.
So the law says you can't borrow beyond your share? The law says Article 79, you can't borrow beyond the nominal share. Remember when we are summarizing our work, conditions to borrow made by directors, borrowing should not exceed the nominal share. You've added this money up here. The nominal share value of the company is 150 something. Okay, these guys want to borrow 200. Does the law allow that?
No.
How do we cure this? The remedy is passing a resolution to increase share capital. Because Article 79 says that unless authorized by the members in the meeting, so that means the members have to increase the share capital. Then after increasing the share capital, because remember the bank will ask for documents, they will ask for the memorandum and articles of association. What if you take the memorandum when they are not amended? So that means after increasing share capital, then you also amend the memorandum to include the new share capital. Okay. Council, let's proceed with our facts. Okay.
Young is willing to mobilize at least 500 million shillings from his family members in China, which he can invest in the company business. Young wants a bigger stake in the company as a result of the above investment.
Which loan is that? Young is a shareholder in the company. So Young wants to borrow the company. So that takes us to what called shareholders loans. Okay?
Loan.
That's another paragraph.
The directors are worried on how to raise the other required monies since they don't have any other securities which could enable the company to secure more credit from financial institutions.
Proceed, Council.
Stanbic Bank has requested Inkoyo Rashid to furnish additional statutory information related to the company in order to ascertain.
Remember one, the borrowing, the section says the directors may. That means the directors have to pass a board resolution authorizing the. So that means you need a board resolution, you need an ordinary resolution and a special resolution. Critical paragraph esembayo ya workshop. Tetukola tasks, tetukola tasks. You know, I do the learning outcomes. Okay. Council, read that boon of the Stanbic Bank again.
Stanbic Bank,
yes,
has requested Inkoyo Rashid,
yes,
to furnish additional statutory information.
So what statutory information are we talking about? The indoor, okay?
I beg your pardon, Council. I beg your pardon.
Okay, so what we are saying that when you look at this, okay, when you look at Article 79, it says the directors may. What does that mean? One, you should prove to Stanbic Bank that the borrowing is authorized by a board resolution. Not so? Then furthermore, you have to prove to Stanbic Bank, okay, that the borrowing is below the share capital. How? By attaching a copy of the memorandum. Because we're going to kusoma memorandum. But tumia memorandum twaja amendize da kati eyitaba tetera tabu. Okay? They talk what is rule in no management. So now, The workshop
Okay,
is done.
Okay.
Simple as that. So what is hard with corporate and commercial? We are all left with workshop too. Okay? Because I reasonably believe we are tired and I'm also a bit exhausted. Okay? So, inshallah, if we get time tomorrow evening or Sunday evening, we shall do workshop too. Okay? But I rarely don't teach on weekends because I need to take a break. Okay? So now, any question, guys? Okay? Yes? Uh-huh.
Preemption.
Preemption. This is the preemption. That's when you issue with a second notice when you are making a call on shares. That's what called to preemption. You can pay back. It does it well. Okay? So now, members, have we achieved our learning outcomes? Okay? Should we read them? My identity. Okay? So, is everything okay, guys? Anyone online with a question, I highly welcome it.
That Tokadi rule.
Backward rule is known as the Indo management rule. What that rule means that anything that is done within the company, the outsiders should not intervene. So whatever is supposed to do, it should be done. Okay?
Anything done inside the company, the outsider should not intervene.
Yes.
That's why Indo abalugadde bya company byakane tebina fuluma.
Another question? Yes, Council Ambrose.
Thank you, Senior Counsel. Counsel, the network had thrown me out. I did not understand this paragraph, which states that Young is willing to mobilize at least Ghana shillings 500 million from his family members in China.
That's what we call shareholders' loans.
Oh,
yes.
Thank you very much.
You're welcome. Another question?
Here, number 3.
Mm-hmm.
Present and prosecute or defend the company.
That is workshop 2. Okay? That is what we call a derivative action. We shall deal with it. Okay? Council Naume.
Thank you for the discussion. I just want to, I don't seem to get a very clear answer on it, where it says that explain if it's possible for Young to participate in decision-making process on behalf of the company or fulfill any obligations as one of the owners, draft any relevant documents. What documents are they envisaging in that case?
Remember, it depends the task, okay? One, remember, Young has to get involved in decision making, okay? That is by attending the meetings and pass resolutions and sign them. But Young is in China, and China, you can't access that. So you go to what we call court-ordered meetings. You make an application by notice of motion, and the court passes an order for you to issue what we call circulation meetings, okay?
Okay, thank you.
Okay. So, guys, allow me bring this session to an end. It has really been a marathon. This is one of our longest online sessions. Okay. So let me wish you the best over the weekend. May the good Lord allow you end first term in peace, but not in pieces. Okay. Remember, this is one of your last classes in first term. You're going for the holiday, but behave. Okay. So on top of that, let me wish you the best. May Lord bless you. Love you all.
Love you too.
God bless you too.
Thank you so much, Council.
God bless you too, Council.